Alex here with part 52 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things to quickly go over are: number one, not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one large 8-year-long example of my personal high-conflict child custody ordeal from beginning to end in chronological order. We left off in the last two parts with some of my dealings, I guess you could say, with the government in my case against the Secretary of State. Part 51 had to do with my reply brief, and part 50 had to do with the government's answering brief. Part 49 is more so where we leave off in this video, because we are back now onto the case involving myself and my ex, the child custody case itself. And this video is not one that is going to go into anything new. In fact, all we're going to go over in this video for the most part is the court's written order, which is the order following the hearing in part, I believe, 49. No, wait, 48. It should be part... Oh, now I'm confused. No, it is part 49 for sure. Part 49, that's the one that has the hearing video. So yeah, this is the final written order. I guess you could call it that. It's we already have a final order. We are now in the post-judgment phase of these proceedings. But it's the first of a series of many more mini final orders that are being entered over and over again throughout the next 4 to 6 years. Part of it's in this case, part of it's in Clark County. But anyway, that's what we're going to see in this video. My mindset was, I guess, okay. I felt like I resolved the problem to the best extent that the judge could understand, but for the most part, I was disturbed because of the impression the judge gave me, which is to not file things, not because it's good for your kids, but because it's just too much work. You should be able to do it yourselves. And what I mean by too much work is it's too much work for the court. So stop filing stuff. Too much work for the court, too much work for the lawyers. Leave us alone. Sort your own problems out. And I don't think I really felt like I had any way to sort of go over his head. I think after this order, we do have a bit of a break, but I'm not sure. The only reason I say that is because if I remember correctly, at some point in 2010, there was a several months long break, maybe even a year and a half possibly, where there was little litigation going on with my ex, but there was a whole lot of nonsense going on outside of the court. And it might have been at this point in time because of the fear that the judge felt was necessary to instill in me. So I'm not sure if it's right now or if it's coming very soon, but there is a gap of time where not much is done, and it's not a very large gap. It's not like a 2-year gap. It's probably around, as I mentioned, 12 to 18 months worth of a gap. But let's go ahead now and actually take a look at what the judge has filed. Here we have the judge's order after hearing. First paragraph, the first thing that I noticed that isn't correct is that he has it down as a settlement conference, but it wasn't. This is probably just something that they copy-pasted, and whoever worked on this order for him didn't backspace that out and replace it with review hearing. The February 23rd, 2010 hearing was a review hearing, not a settlement conference. I was there representing myself in proper person. He indicates that my ex was there through and by her attorney, Kathrine Berning. The next paragraph here is the first of his order, and that is that my ex shall henceforth give me 14 days notice via email, which I think for the most part she complies. She does frustrate this. I think a year or two later, I know for sure she does frustrate. I just don't remember for sure the timeline, but the way she does it is by claiming emergencies that aren't really emergencies. We'll talk about that when that actually comes up in the series. Second provision here is that I shall respond to any of her emails in a timely manner, indicating which days I'll be able to attend those appointments. The third paragraph indicates that my motion was denied, which it really wasn't, because paragraphs 1 and 2 are a procedure. He just didn't set the procedure I requested. So, I mean, there might have been something else in there, in that motion. I think something about taking turns. I don't know. I mean, it's just probably something that my ex requested to be inserted into this order, because the judge didn't set the procedure that I requested, but he did set a procedure, and that's basically the 14 days notice thing. Scrolling down, we have the penalty for violation of order, which I've gone over before. It's just standard boilerplate. We have a statute in Nevada that mandates that this language is included in any court order entered in a child custody case, and it just warns the parents not to run off with the kids, or you face a felony. Next document, we have the request for submission. This is the document that indicates to the court that whatever it is that's been submitted is now ready for the court's attention. Otherwise, the court won't even know it has to take a look at something. I have a video called Request for Submission that goes into the details as to how this works. In Nevada, only 2 or 3 counties actually even bother using this procedure, the request for submission procedure. The rest of the counties, and I don't even think any of the justice courts, not a single one, uses this process at all. But I do want to let people know that I, who was litigating in the Second Judicial District Court, which is Washoe County, did have to use requests for submissions, and there are a few other counties out there that do as well. Certificate of service by mailing just indicates that this order was mailed to me. Now, this is a little bit confusing, I think, for some viewers who don't know what's going on, but this order, after hearing that it's referring to here, is not the one that was just signed by the judge. This is the proposed order, the one that was proposed by my ex, well, by my ex's attorney, to me as an order that reflected what actually occurred at the hearing, and it's going to be identical to the one we just went over because I didn't object to it. Otherwise, we would have gone over an objection as we did earlier in this series. I can't remember when, but I think it was somewhere in the 20s or the 30s of the My Docket series where I filed an objection to a proposed order. In this case, I didn't file an objection, so it was just very smoothly, it just went through smoothly. Oh, by the way, please take a look at proposed orders. It's a video that explains exactly what they are. The words proposed order in and of themselves don't do it justice as to how crucial it is to understand how this process works and what can happen if you don't know what you're doing when you get a proposed order from your opponent's attorney. Index of exhibits, this is going to be the letter and the proposed order attached to the letter. Right now, our electronic filing system is down. It's going to be up later, and you'll be able to click on the link down in the description below and download this document for yourself probably a day or two from the day that I published this video, and you should have the updated version of this document, which will contain the letter if you want to take a look at it. But it's not going to be anything really new. It's just going to be a letter that says something like, Mr. Falcone attaches a proposed order. If you have an objection, make sure you file one within, I don't know, a certain number of days according to the court rules, something like that. And then, of course, it'll contain a copy of the previous order that we already went over, with the exception that this one will have a blank signature line. Notice of entry of order. This is our next document. Now, this here is the notice that is filed after the judge has actually signed the order. That's what's going to be different between this and the previous request for submission that you just took a look at. The notice of entry of order will contain, as Exhibit 1, the copy of the signed order after hearing. Now, I like to mention that it's a little silly to look at it just as a notice because the court itself will mail the order to you anyway. You don't have to get it from your ex's attorney, but there is more to this than meets the eye. I have a video on notice of entry of order, which explains what these documents do in Nevada. It basically triggers the deadline to file an appeal. Definitely take a look at the video notice of entry of order if you haven't seen it yet, because it's more than just literal notice of the order. It's triggering timelines. Certificate of mailing, which just indicates to the court that my ex's attorney mailed this to me at my address. And this is consistent with Rule 5, which allows you to serve upon your opponent documents through the mail. Not all documents, but most. There's very few exceptions. The initial pleading is one, and a subpoena is another good example of another. And the summons. This is an index of exhibits, which has Exhibit 1, which is a document we've already gone over, order after hearing issued. And so we're not going to go over this again. We'll move on to the next document. This is the notice of non-availability. You've seen at least one of these before by now, maybe two, but I think it's just one. And this just lets the court and me know that my ex's attorney will be unavailable for a certain period of time. Some people have raised concerns to me with regards to notice of non-availabilities and how they might be able to abuse a person's right to access the courts. I have a video dedicated to this topic where I speculate how I think that might end up being dealt with, but it never happened in my case. Anytime my ex's attorney was unavailable, it was typically for a few days or a week. And in this case, she's unavailable for one single week. The attorney is probably going on a trip or something, a vacation, who knows. Another certificate of service by mailing, which indicates to me, oops, another typo here. She says that this notice of entry of order was mailed to me, but it's not a notice of entry of order. It's a notice of non-availability. So her paralegal probably just forgot to backspace this piece out. They probably just copy and pasted it. I'm going to take a look at that previous document really quickly. Yeah, notice of entry of order, and here we have it again. So whoever it is, this guy, Barry Blau, he probably just didn't backspace this notice of entry of order out and replace it. It happens. Next document, we have my notice of change of address, and I'm just letting my ex and her attorney know that I am no longer residing at the previous address and I have a new address, and this is a crucial document to file. In fact, I could have sworn I filed. Oh yes, I did go over one of these in my previous video, but that was in the other case. That was in the case against the Secretary of State. So I did let the Secretary of State know in the previous video that I had moved, and here I am letting my ex's attorney know, in this case, the child custody action, that I have moved. Now, I have a video called Notice of Change of Address. I already talked about in the previous video why it's important to watch that video, so I'm not going to go ahead and do that again now. But yes, definitely take a look at that video, because if you don't file a notice of change of address when you move, documents may get sent to your old address, and you will be considered to have been served, despite the fact that you didn't get them. Next document here, we have the certificate of service by mailing. This is a document that lets the court know that I mailed the notice of the notice of change of address to my ex's attorney. I've talked about this, it's been a while now, but I just want to remind my viewers that I don't have to keep filing these separate certificates. I can just attach this to the bottom of the notice of change of address, and that is perfectly fine, and in fact the courts prefer it because that's just one less filing, one less entry on the docket. But I haven't realized that yet. I'm still in 2010. I still don't fully understand everything that I do now, and so I continue to file these documents separately. But yes, as you see my attorney doing, she did in both of those previous notices. She did it in the request for submission as well. She's including the certificates in the actual document itself that's being filed, and I haven't started to do that yet, but I want to let my viewers know that I can do that too. It's not just something that attorneys can do. Here's my affirmation, which just lets the clerk of the court know that this document does not contain a social security number. The court has entered an order disposing of one motion. It is my motion to set a procedure for medical, dental, vision, and educational appointments. Although on its face the order was denied, he does actually set a procedure. It's just not the one that I had requested in the motion, and that is for my ex to provide 14 days notice from now on before scheduling these non-emergency appointments. Going into the aftermath, the court filed one document, my ex's attorney filed 3, and I filed 2. The documents that I filed were free filings, so I incurred $0 in costs. The documents that my ex's attorney filed were also free filings, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's go through these one by one. The notice of entry of order, 5 minutes for her to prepare. It's just one of those boilerplate documents that she probably just has her paralegal do it for the most part, and it's just replacing captions, case numbers, stuff like that. So 5 minutes for the notice of entry of order. Notice of non-availability, I guess that would be 5 minutes as well. That's just really her telling the court and myself that she's not going to be available for certain dates. The notice of change of address that I filed, I'm going to go ahead and say 5 minutes to update in her computer systems the address that I reside at, so they know where to send mail to. So we're at 15 minutes so far. The certificate of service by mail that I filed, it's negligible. I'm not even going to count any time for that. The request for submission and the order after hearing, I think I'm going to lump these two together because for the most part it's the same thing. It's a court order that was prepared by my ex's attorney and ultimately signed by the judge. I think that these documents would have taken about 30 minutes, not so much for her to review or for even her to prepare, but for the proposed order itself. That is probably what took most of the time there. Actually, I'm going to go ahead and raise that to 45 minutes because preparing an order is something that, even if it's short, it still takes some thought. So 45 minutes in preparing that order and the request for submission and reviewing the order after hearing, I think that's pretty reasonable. Combined with the 15 minutes for the other documents, we're at 1 hour. And at the rate of $250 an hour, my ex's attorney fees would be $250. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.